specialising in employment law, and I've been doing that job now for a bit over 7 years. As Liz has said, this is the third in a series of webinars covering issues regarding unfair dismissal claims. I started with a general overview of the law on unfair dismissal, and last month we covered dismissals on the grounds of misconduct. If you missed those, please do log in and have a listen at your leisure. Today I'm here to talk to you about the key legal and practical issues that arise in cases where employers are concerned about the capability of employees. Capability dismissals tend to fall into one of two camps. Dismissals because of competence of employees, or rather the lack of it, and dismissals on the grounds of ill health. We're going to look at both of those in turn, and as Liz has said, there should be time for questions at the end of the webinar. But if you have anything that you wish to discuss in detail, you'll find my contact details at the end of these slides, so do get in touch. The current provisions regarding unfair dismissals are contained in the Employment Rights Act 1996, which provides that the dismissal of a qualifying employee will be unfair unless, first, the employer can show that the reason or the principal reason for the dismissal was a potentially fair reason, and capability is one of the potentially fair reasons. Secondly, the tribunal finds that in all the circumstances, including the employer's size and administrative resources, that the employer acted reasonably in treating that reason as a sufficient reason for dismissal. That means that the dismissal must be both procedurally and substantively fair. The statutory definition of capability as a reason for dismissal is set out under Section 98(3)A of the ERA, and it encompasses competence, health and qualifications. Section 98(2)A, as I've set out, provides that a reason falls within this subsection if it relates to the capability or qualifications of the employee for performing work of the kind which he was employed by the employer to do. And Section 98(3), which I've paraphrased on the slide there, puts a bit of a gloss on that. Capability means capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. And qualifications means any degree, diploma, or other academic, technical, or professional qualification relevant to the position which he held. Looking at fair procedure in these kind of situations, provided one or more of the potentially fair reasons for dismissal applies, whether a dismissal is fair will depend on the reasonableness of the employer's decision in the particular circumstances and the procedure followed. In the context of dismissal for capability reasons, the tribunal will not only want to be satisfied that the employer honestly believed on reasonable grounds that the employer, sorry, I'm just getting a bit of rustling there, we're just going to sort that out. Hi everyone, sorry about that, I'm back. So yeah, where was I? In the context of dismissal for capability reasons, the tribunal will not only want to be satisfied that the employer honestly believed on reasonable grounds that the employee was incapable of performing their job, but with regard to the overall reasonableness of that decision, will consider whether management failed to discharge its own responsibilities towards the employee. An important element of this will be the extent to which the employer has clearly communicated the requirements of the role to the employee, or where applicable, has provided necessary support and training. It's a basic principle of fairness that a decision to dismiss or take other disciplinary action should not be taken without a disciplinary hearing or a meeting. And generally, case law has established that a dismissal for poor performance will not be fair unless the following key elements are present. 1, a proper investigation into the problem has taken place. 2, the employee has been made aware of the problem and has been given an opportunity to improve within a realistic timescale. 3, the employee has been provided with appropriate support and possibly training. 4, the employee's progress is reviewed during the review period. And finally, the employee is offered a right of appeal against the decision to dismiss. To help employers and employees deal effectively with issues of alleged misconduct or poor performance, ACAS has produced the ACAS Code of Practice on Disciplinary and Grievance Procedures and some supporting non-statutory guidance. It's not a legal requirement for the ACAS Code to be followed, but employers should have regard to it, as an employment tribunal is obliged to consider the ACAS Code when deciding whether a dismissal is fair, and specifically whether a fair dismissal procedure has been followed. Also, be aware that an unreasonable failure to follow the code by either party may result in compensation being increased or decreased by up to 25%. The content of the ACAS code doesn't really add much to best practice and the existing case law, but it is nevertheless essential reading for anybody involved in investigations and disciplinary hearings, so please make sure you're familiar with it. And I've put a link on the slide there where you can download a copy of the code from the internet. Setting the standard required. Express terms aside, it's implied into every contract of employment that an employee will perform the role to a minimum required standard. What the required standard is will vary from role to role, and it may encompass not only the technical aspects of the job, but more subjective aspects, such as the employee's attitude or ability to interact with clients and colleagues. Some requirements of the job are so obvious that the employee's attention doesn't need to be drawn to them. For example, there were some observations made in a case called Burns and Turboflex Limited, where it was said that a van driver does not need to be warned that he should not drink before he drives. The personnel director of a large company does not need to be told he should not make racist or sexist comments about or to members of his staff. And a pilot does not need to be warned that he should not crash the plane. Aside from very obvious requirements of the job, it is important for the employer to have drawn the employee's attention to the required standard, usually at the outset of employment, and then if it becomes necessary, for the purposes of a capability procedure. If performance targets apply, for example, a tribunal will want to be satisfied that an employee could reasonably be expected to have known about them. Were targets brought to their attention? Were they made aware of the possible consequences of not meeting certain targets? Probation periods are a useful tool for employers. They are frequently used for new recruits and are often set at between 3 and 6 months. That's an ideal time for an employer to assess an employee's suitability for the role. That's because the employer's exposure to claims during this period is limited for two main reasons. First, the contract is likely to be terminable during the probation period on a week's notice. And secondly, the employee won't have acquired the qualifying period necessary for most unfair dismissal claims. An employer may also want to reserve the right to extend the probationary period for a further limited period. If an employee doesn't perform to the required standard during the probationary period, they may be dismissed before the period expires. There's no requirement that the employee be allowed to complete the full period. Alternatively, at the end of a probationary period, the employer may confirm satisfactory completion of the probation. It is important that employers diarise the period of probation carefully to ensure that the date is noted, the end date is noted, and that a decision as to satisfactory completion or otherwise is reached and communicated to the employee before that date passes. If an employer fails to communicate with the employee at the end of the probationary period, it's likely that the period will lapse. Probationary periods can also be applied for those promoted to a new role. Where applicable, a probationary period needs to be clearly communicated to the employee. Providing this is done, the employee will be aware that they are under review and that they must satisfy the employer of their suitability for the role before the contract is affirmed. By entering into a probationary period, the employer is expected to conduct a reasonable appraisal of the employee's performance and to bring any inadequacies to their attention so that they're given the opportunity to improve. As the next slide says, appraisals are important. To demonstrate a reasonable belief that an employee is incompetent so as to justify dismissal, employers need to produce some evidence of poor performance. Whilst that may be gleaned from data such as sales or productivity reports, records of customer complaints, or a demonstrable fall-off in trade, the most important evidence will often be provided by those managing and supervising the individuals concerned. A performance appraisal system that is diligently pursued by the employer can prove invaluable in motivating staff, but can also provide important evidence of performance problems which can later be used to support a fair dismissal. In the event of dismissal, the employer is also likely to be better placed to demonstrate that opportunity for improvement has been given if regular appraisals have been undertaken. In order to be effective, appraisals should be conducted honestly. Managers who provide unduly positive or flattering feedback which doesn't reflect the employee's true performance may find that this is later used to undermine an employer's argument that belief in incapability was reasonably held. Employers who fail to tackle performance issues through an appraisal system may also find it will hamper their future business decisions in other respects. For example, in redundancy situations, employers wanting to give someone a low score for performance will be hindered if a low score isn't corroborated by past appraisals. Poor performance can take many different forms, but some common examples include lack of productivity or slowness, inflexibility, and failure to establish good working relationships with colleagues or customers. Addressing performance issues as soon as they arise is important from a legal perspective and can also have a number of advantages for both employers and employees. For example, an employee is more likely to turn their performance around if concerns are highlighted at an early stage than if matters are left to fester. If offering training and support results in a positive outcome, then that's less time-consuming and costly than going through a poor performance dismissal procedure and recruiting a replacement. And being able to demonstrate that an employee has been given support and the opportunity to improve will greatly improve the employer's chance of effecting a fair dismissal. What I would say is avoid taking a heavy-handed approach. In seeking to address performance issues, it's unlikely that an employer who follows a reasonable procedure will break trust and confidence in the employment relationship. However, the employer must take care not to criticise or embarrass a poorly performing employee in front of colleagues. There was a case of Hilton International Hotels Limited versus Protopapa. There, the claimant's supervisor reprimanded her severely in front of other employees. Upholding her claim for unfair dismissal, the EAT found, that's the Employment Appeal Tribunal, found that she had been humiliated, intimidated and degraded to such an extent that there was a breach of trust and confidence which went to the root of the contract. And that was the case even though the supervisor would have had no authority to dismiss her. One of the questions which has been put forward ahead of this webinar is whether capability and disciplinary need to be kept separate. And the answer really comes down to how you analyse the situation before you. Is performance really the issue? When investigating the problem, employers sometimes find that there are other issues that need to be addressed instead of or in addition to the poor performance. For example, ill health or disability, problems with childcare or caring responsibilities, poor management within the team, harassment or bullying by a manager, or an excessive workload leading to inability to deliver and stress for the employee. We will come on to ill health dismissals shortly, but where poor performance is caused or exacerbated by a disability, employers will need to comply with the disability provisions of the Equality Act 2010. Once disability is identified, any decisions taken by the employer, such as a warning or a dismissal, will need to be a proportionate means of achieving a legitimate aim. And before reaching any such decision, the employer will need to consider what reasonable adjustments it might make to support the employee. Adjustments might include the supportive steps that an employer would consider for any underperforming individual, such as additional training or support. It might be role-specific adjustments, and equally the employer may also need to consider an adjustment to the capability procedure itself. Dismissing fairly for poor performance. It's for the employer to establish the reason or the principal reason for dismissal in any unfair dismissal claim. Lack of clear evidence of poor performance is therefore likely to prevent the employer demonstrating that as a reason for dismissal, and that takes us back to the appraisals which I've just discussed. Where the employer has dismissed an employee for incompetence, it will have to show that it had a reasonable belief in the employee's incompetence when it took the decision to dismiss. Inevitably, to satisfy this test, there must be evidence of the poor performance, or the employer will struggle to show that the grounds for its belief are reasonable. The appraisal system is most likely to reveal the poor performance, but there might also be relevant further evidence, for example, a fall-off in trade. One thing to note when you carry out these kinds of dismissals is that you cannot rely on issues which only come to light after the decision to dismiss has been taken in order to justify a decision and show that the belief is reasonable. Before embarking on any course of action, an employer should carry out an assessment or investigation. provide the employee with the findings of that investigation, and allow them the opportunity to respond. This may involve interviewing the employee and/or presenting them with collated evidence to comment on. The employee doesn't have the right to be accompanied at an investigatory meeting, but does have the right to be accompanied by a trade union official or fellow employee at a hearing that could result in any disciplinary action being taken. Any capability procedures should be referred to in the context of the investigation, or if you don't have one of those, refer to the ACAS code. Where it's relevant and helpful to do so, managers should also refer to one or more of the following documents: the employment contract and an up-to-date job description, training records, performance appraisals, the staff handbook or operating procedures, and any previous action plan under a poor performance procedure. Full notes of the investigation, including notes taken during meetings with the employee, should be retained for future reference. A preliminary investigation may reveal underlying reasons for the underperformance, which the employer will need to consider before deciding on the next step. For example, any issues which may involve fault on the part of the employer should be addressed, such as failure to provide training or the existence of poor management. Similarly, any indications of ill health or physical impairment should be investigated further, in case the employer needs to consider making any adjustments in the case of disability. As a result of the investigation, the employer may decide to take no further action, or else to hold a formal meeting which may result in a written warning. Warnings should make clear what is required of the employee, the standards they are expected to meet, and the timescale for improvement. What is a reasonable timescale for improvement? Well, that's a fact-sensitive question, and it will depend on the circumstances and the role in question. If a capability procedure provides for a certain timescale for improvement, then that should be adhered to. And equally, if there's an industry standard that's considered reasonable, that can be used as well. In the absence of timescales set out in a capability procedure, the quality and length of the employee's past service may be a relevant factor, as will the extent of the underperformance. But tribunals won't adopt a tariff approach to the timescale question. They'll focus instead on what was reasonable in all the circumstances. Often it makes sense for employers to link the timescale to a natural part of the business cycle, for example, a quarterly sales target period or the duration of the particular phase of a project. The extent to which relationships with the customer or other third party are affected by the underperformance may also be relevant to the timescale given for improvement. It's really important for the employer to diarise the review period, having notified the employee that their performance will be monitored and discussed, usually halfway through the timescale set for improvement. It's likely to be unreasonable if the employer fails to adhere to this. Where the employee fails to improve sufficiently, a formal meeting should be arranged. The employee should be notified in writing of the following: the nature of the shortcomings in their performance, the date, time and place of the capability meeting, a summary of the relevant information and any relevant documents, the procedure to be followed, the possible consequences if performance is found to have fallen short of the required standard, and the right to be accompanied. Whilst there's no absolute obligation on an employer to consider alternative employment or demotion before taking a decision to dismiss, it may be unreasonable in the circumstances not to do so, depending on the size and the administrative resources of the employer. Just a couple of common issues before we move on to the issue of ill health. It will be relatively rare that poor performance in the absence of any deliberate or willful element will be so grave as to justify instant dismissal for a single act of incompetence. Inherently hazardous roles may provide an exception, but in the vast majority of situations, employers are expected to investigate and to consider offering support to facilitate improved performance before they can reasonably contemplate a dismissal. What about the situation where employees who lapse, where the employees are given a warning period, they improve during that warning period, but then they lapse afterwards? The ACAS code has provided guidance on that. Sorry, the ACAS guide, not the code. And that suggests that in those circumstances, it may well be reasonable for an employer to impose a longer warning period than usual, pointing out to the employee that there needs to be a sustained improvement. But the key headlines from this are: make sure the employee knows what is expected of them, make sure they know if they are falling short, and give them the opportunity to get back up to standard. Ill health is a subject which it can be a bit of a headache for most employers. Most dismissals that take place following a lengthy period of sickness absence will be by reason of the employee's incapability to do the job. However, there are other potentially fair reasons for dismissal that may be relevant when someone is dismissed following a period or periods of sickness absence. Short-term intermittent absences, even if for genuine ill health reasons, could give rise to a some other substantial reason type dismissal if they have a significant detrimental impact on the employer's business and the employee's performance. And persistent unauthorised absences may give rise to a conduct dismissal if no valid reason is given for the absence or the employer's sickness reporting procedure has been breached. Again, it's necessary to follow a fair procedure, but note that the ACAS code does not apply to these kinds of dismissals. The principles governing procedural fairness in cases of dismissal for genuine ill health, rather than the misconduct type ill health, are established by case law. The leading case on fairness in ill health dismissals made clear that the employer should establish the true medical position and consult with the employee before deciding whether to dismiss. That case is called East Lindsey District Council and Daubney. Exceptional circumstances may exist where the nature of the role or the terms of the contract make clear that a certain level of robustness is required for the employment to continue. For example, in the case of Leonard and Ferguson Haynes Civil Engineering Limited, the dismissal of a steel fixer on an oil rig, which was a role which required particular robustness, for failing to reach collectively agreed attendance targets was held to be fair. In the vast majority of cases, the Daubney guidelines will apply. However, the position may be different with regard to short-term intermittent absences. There are a number of factors which are likely to be relevant when considering the reasonableness of the decision to dismiss: the nature of the employee's illness, the prospects of the employee returning to work and the likelihood of the recurrence of the illness, the need for the employer to have someone doing the work, the effect of the absences on the rest of the workforce, the extent to which the employee was made aware of the position, and the employee's length of service. In general cases of long-term absence, they're more likely to require further investigation into the medical position beyond sick notes. Hang on one, there we go. We're up to date on the slides. They're likely to require further investigation into the medical position than cases of short-term absence. Where there is an underlying health condition, it's likely to be possible to obtain a medical opinion about when a person will be fit enough for work. The employer will want to understand the underlying health condition and the prognosis, and also to consider whether the employee is suffering from a disability, as we've already touched on. We've just got a question come up there, and I'll deal with that now. How is length of service relevant? This really depends on whether we're dealing with a disability ill health dismissal or a non-disability ill health dismissal. If you have a normal capability dismissal where there is no long-term underlying factor, which may be a disability, then an employee cannot bring a claim with regards to dismissal unless they have been engaged for 2 years. So that's with regards to disability, there's an allegation of discrimination, then there's no qualifying period for bringing a claim. So that'll be a relevant factor. But equally with regards to length of service in terms of the factors to be considered when discussing the reasonableness of the decision to dismiss, you'll want to look at the overall impact that an absence has on the ability of the business to function. If you have somebody who has, for example, 6 months off sick because they've had a grave accident or they're suffering from a long-term illness that takes that long to recover, it's more likely to be detrimental to the business to have somebody taking that kind of time off if they've only been in the business 1 or 2 years, for example. If you are presented with somebody who has that kind of exceptional ill health absence, but they've been an employee for 20 years with a fairly good absence record, then that is likely to require additional consideration. Generally, the case law which has been handed down from the employment tribunals and the employment appeal tribunals says that tribunals take a much better view of employers who deal sympathetically with their employees, albeit reasonably, but sympathetically rather than being hard-nosed and well, I can't think of the appropriate word, but I'm not saying take a softly approach, but do consider whether you can accommodate a particularly long-serving employee's absence. We were talking about medical opinions and the fact that the employer will want to understand the underlying health condition and prognosis, and also to consider whether the employee is suffering from a disability. As I've mentioned a few times, if the employee is suffering from a disability, then the employer is under a duty to make reasonable adjustments and has a duty not to discriminate. In cases of long-term absence, case law has established that fairness will involve the following key elements: ascertaining the medical position, consulting with the employee, and considering the availability of available employment. With regards to ascertaining the medical position, a report may be needed from more than one health professional, for example, the employee's GP, an occupational health physician, or a doctor retained by the employer. It's important to remember that the decision to dismiss is a managerial one, not a medical one. Whilst the views of the experts will help an employer in coming to a decision, the experts shouldn't dictate the outcome. Assuming that a tribunal is satisfied that an employer has followed a fair procedure, the final question will be whether the employee can be expected to keep that employee's job open any longer. How much longer an employer may be reasonably expected to wait will be fact sensitive, and it will be based on the nature and the context of the employee's job and their illness. Relevant factors may be the availability of temporary cover and the cost of that cover, the fact that the employee has exhausted his sick pay, the administrative costs that might be incurred by keeping the employee on the books, and the size of the organisation. We've got a question. I'm just about to move on to short-term intermittent absence. So we've got a question that's just come up here. What do you do if your employee on long-term sick will not engage with occupational health in order for you to gain a medical opinion? Well, of course, you can't require them to attend a medical investigation or a medical appointment. It has to be done with their consent. If they are unreasonably refusing to do that, it may be that it is a disciplinary matter and you want to consider issuing them with a warning. Equally, you could continue to deal with it on the basis of the capability procedure. I'd probably recommend dealing with it only on the basis of capability, and to explain to them in no uncertain terms that you are in the process of considering whether or not you are in a position to sustain the absence. In order to do that, you need to know what the prognosis is and whether they're likely to return within a reasonable period. If they are unable or unwilling to provide you with that information, then you will have no option but to make a decision without that information available. You should still probably try to make some kind of investigation. It could be a simple case of Googling it, for example. As long as you show that you've done something to try and assess the likelihood of what will happen in the future, then you're probably on safe ground. It is rare that when people are genuinely ill that they won't engage with occupational health, certainly in my experience. If the refusal to engage with occupational health gives you reason to suspect that their illness is not genuine, then of course that could well be a misconduct issue because they would potentially be abusing the absence procedures. So really it's fact sensitive. It depends on their reasons for objecting. Usually employees can be placated by giving them the option to see a report before it's handed over to their employer. Yeah, you can't strong-arm them, I'm afraid. Cases of persistent short-term intermittent absence may be more difficult to deal with than long-term absence, as it's often hard to predict if attendance will improve. Where there are persistent short-term absences and no underlying health condition, a medical expert's unlikely to be able to predict with any more certainty than a manager when the employee is likely to show a sustained improvement in attendance. So for this reason, the role of the medical evidence may differ depending on the nature of the absence. The leading case on short-term intermittent absences is Linecock versus Cereal Packaging Limited. It's a 1988 case, but it's still used a lot. In this case, the Employment Appeal Tribunal held that it was fair to dismiss an employee suffering from short-term unconnected illnesses without first obtaining a medical report. The EAT recognised that little purpose could be served where there was no underlying health condition to investigate in obtaining a medical opinion. The EAT there relied on an earlier EAT decision in which it was stated that the proper approach in those cases is to review the pattern of absences and the reason for them, to warn the employee of the required improvement in attendance, giving them the chance to make representations, and finally consider whether there is the required improvement in attendance. If not, dismissal is likely to be reasonable. However, just a word of warning on this one. Linecock should be treated with some caution, as there may be some cases where short-term absences are apparently unconnected but in fact relate to an underlying health condition, for example, ME. Given that there's also scope for an employer to discriminate against an employee where, although it wasn't in fact aware of the disability, it ought to have been, the employer should at least satisfy itself that there is no underlying health condition before adopting the relatively straightforward procedure which I've just explained. In cases of short-term intermittent absence, fairness will mean ensuring that the employer is aware of the standards of performance expected of them, the impact their absence is having on the employer's business and their colleagues, and the likely consequences of formal action or dismissal in the event of their continued absence. We've got another question here which sort of links back to the earlier one I've just dealt with, but we'll take a step back and have a look at it. What do you do if the employee is long-term absent and will not communicate at all when occupational health have confirmed that there are mental health issues? Well, I think really you're backed into a corner in that one. It's all a case of fact-sensitive. What's the situation in the circumstances? If there are mental health issues which may or may not give rise to disability, and it may do if it's a long-term condition which has a substantial adverse effect on day-to-day activities, then if there is a risk that there is a disability, what you need to do is make sure that any dismissal or any disciplinary procedure or capability procedure is a reasonable, is a proportionate means of achieving a legitimate aim. Now, attendance at work is of course a legitimate aim. Business decisions are, or business management are legitimate aims. If you need that person in the office and you can't continue to justify temporary cover and all the rest of it, then, and you can show that there has been a refusal to deal with occupational health or to provide any other medical evidence, then it seems to me that you would be on fairly good grounds, and I say this cautiously because obviously I don't know the facts of your case, but it seems to me that you would be on relatively safe grounds to say that dismissal in those circumstances where the employee is no longer cooperating, it's reasonable to achieve your business aims by dismissing them and recruiting somebody in their place. All I would say is document it all. Make sure you've got any notes in writing. Make sure, as I keep saying, that the employee knows exactly what is required of them, both in terms of attendance and also in terms of cooperation. And then you can't be expected to hold their job open indefinitely. There comes a point where you'll have no other business option really than to dismiss. As long as you can document it all and as long as you're objectively reasonable as you do it, then it would be difficult for any criticism to be levied against you. So I hope that helps. If you've got any more specific queries on that, then do feel free to drop me an email and we can have a chat about it. One tricky point which does crop up is dismissing an employee on sickness grounds before they've exhausted their right to contractual sick pay. That won't necessarily be unfair. The continuing existence of contractual benefits is only one of the factors that a tribunal will consider when evaluating the overall fairness of the dismissal. There's an important case on this called Coulson and Felixstowe Dock and Railway Company, which is a 1975 case. There, an employee who is entitled to receive 6 months full pay and 6 months half pay under a contractual payment scheme was dismissed after lengthy absences, but before his entitlement to pay was exhausted. He tried to argue that because he was entitled to have 2 lots of 6 months payment, a year's payment for sick leave, that it was unreasonable to dismiss him before the end of that year. The tribunal found that the employee's dismissal was fair and that the sick pay was a financial provision and not a provision which in any way indicates the amount of absence to which an employee is entitled if he is sick. An important factor will be the likely timing of the employee's return to work, as evidenced by any medical reports. If the employee is clearly unlikely to return to work within the period for which his sick pay would continue to run, then a dismissal before the expiry of the pay is more likely to be fair. However, if there is evidence to suggest that the employee may be fit to return to work before his sick pay would have expired, the dismissal may be considered unfair, having taken account of other factors relevant to fairness. We're talking about, we've just got a question here. You've mentioned company sick pay. Is it also prudent to wait until SSP has also been exhausted? No, the point here is it's all fact sensitive. I keep saying this. It's probably not particularly helpful. The length or otherwise of sick pay, whether it's contractual or whether it's statutory, is not a relevant, or rather it's not a definitive factor. So Coulson and Felixstowe Dock and Railway would likely apply, well it does apply equally to the contractual payment scheme for sickness and the statutory provisions. So if, for example, they have so much contractual absence and then thereafter statutory sick pay, the question is when are they going to return to work, and or are they going to return to work at all? Just because they are entitled to receive pay when they are not in work because of absence doesn't mean that there is a guaranteed period of absence which is acceptable. Another question, I have in fact come to the end of what I was going to say. I've noted the last slide is procedure for claiming. That's fairly self-explanatory. You'll all be aware of ACAS early conciliation and the 3-month time limit. So we'll move on to any questions, and we've got one here. What about if you offer permanent health insurance? If you dismiss, you are removing their ability to receive this. The person has a disability that would be covered under the PHI. Really, really tricky question. That's going to depend on the nature of the insurance document, I would imagine. There's no law that I'm aware of in employment law which would answer that. If you dismiss, you are removing their ability to receive this. I don't know. The question is, are you removing their ability to receive it? I don't know. If they have a disability, then no doubt they will be arguing that there is some kind of discrimination by acting the way that you have. If you are acting reasonably in the circumstances, if it's a proportionate means of achieving a legitimate aim, and you can justify the decision to dismiss in those circumstances, then I imagine the insurance policy will simply be a factor to be taken into account. But I can't give you a definitive answer on that, I'm afraid, because I simply don't know the answer. If you want to drop me an email, then feel free, and we can look at that in a bit more detail. We're really close to the wire in terms of time. Has anybody got any more questions that I can try and answer in the next couple of minutes? No one's shouting up, so I'll pass you over to Liz. Thanks ever so much for listening, and do feel free to use and abuse those contact details, which are on the final slide. And I'll see you on the next one. Thanks. Bye.
Thanks, Helen. That's Brilliant, lots of information there. I'm sure we'll all agree. And also, we will put together a document that has got those case references for you when we send over the information. Some information there if you would like to request anything additional. And finally, Helen's next webinar will be on the 17th of March, and that will be focusing on redundancy. And next week, we've got Marie Walsh who'll be giving us an update on that holiday pay law. So goes in hand in hand with what we're saying today. So thank you very much, everybody. Thanks ever so much for joining us today, and I look forward to seeing you again shortly. Thank you.